Welcome to the deep dive. Today we're cutting through some of the really dense jargon of South African wealth management to look at something intensely personal and often tragic, the fate of the family business.
Yeah, we're focusing on two families, one in Gauteng, one in KZN. Both were wildly successful, worth tens of millions, built over decades of pure sacrifice.
And here's the really dramatic contrast we found in the sources. One family saw their entire legacy, their construction firm, their capital, and critically their relationships, just gutted in less than 18 months after the founder passed away.
Well, the other family, they're in manufacturing, and they are absolutely thriving today. They've seamlessly transferred, well, 9 figures of wealth to the third generation.
And the single defining factor between that survival and total collapse was structure, specifically strategic planning, using a trust structure. Our sources call it the asset protection fortress. Okay, let's unpack this. Our mission today is to extract the exact blueprint for how South African business owners can ensure their hard-won wealth becomes a lasting legacy and not, a financial disaster just waiting to happen.
And this deep dive, it's really tailor-made for you if you generate income, if you're building assets, or if you run a family business in South Africa. We're providing clear structure, specific details, not just to understand the risk, but, well, to apply the remedy.
So you can stop feeling overwhelmed by all the info overload that just plagues this topic.
Exactly.
Let's jump straight in. Section 1, the South African succession time bomb. What's so fascinating here is that unlike a lot of other places, South Africa's legal and tax environment, it almost seems uniquely designed to punish inaction, to make succession risk worse.
Oh, absolutely. It's not simply a matter of having a good will, is it?
Not at all.
The system is aggressive. I mean, if you die without the right structural protections, like that fortress we mentioned, your assets face multiple simultaneous attacks from the very moment the master's office opens that estate file.
And these aren't small attacks, are they? Can you walk us through the specific financial threats that target this unshielded family wealth?
Sure. So first, the most obvious one, estate duty. The state claims 20% on the value of the estate above 30 million rand.
20%.
And that rate jumps to 25% thereafter. That is a massive chunk of liquid capital that suddenly needs to be found.
And that tax liability is often compounded by the next threat.
Precisely. You have capital gains tax, or CGT, which is triggered simply by transferring assets out of the estate to the heirs. These two taxes alone can demand millions in cash.
Creating a desperate liquidity crisis for the survivors.
A desperate one. And we also have to flag what the source material calls the silent killer for a lot of existing older structures, Section 7C.
Okay, what's that?
This is a huge hidden risk. Section 7C is a deemed donation tax. It's levied on interest-free loans that business owners often made to their trusts years ago.
So they set up a trust, loaned it money to buy a property, and then just forgot about it.
They forgot about it. But SARS doesn't. They see those interest-free loans as annual donations, and penalties can be ruinous. I mean, potentially hundreds of thousands or even millions if it's not fixed correctly.
That truly feels like a trap just waiting to spring, years after the owner thought they'd done the right thing.
It is. And then don't forget the risks outside of tax. The Matrimonial Property Act, particularly the accrual system, can allow a divorcing spouse to claim a huge portion of the business's value if it's in your personal name.
And creditors.
Aggressive creditor pursuit under our insolvency laws can target everything you own personally if there's no shield.
So the bottom line is the South African context just demands proactive planning.
Yeah.
And yet there's this statistic that drives home the urgency.
68%.
68% of South African family businesses have no formal succession plan.
Which brings us right to Section 2, the cautionary tale of loss. The Vandermaury collapse provides a perfect lesson in why this proactive planning is...
Well, it's just non-negotiable. Okay, let's look at Peter Vanderburgh. What was the setup of his business before the tragedy struck?
Peter had built this respected Johannesburg construction company, valued at about 50 million rand. He had 3 children, 2 active in the business, Johan and Annelies, and 1 uninvolved doctor, Francois, down in Cape Town.
And his plan?
His formal plan was a basic will. It split the company's shares and assets equally among the 3, based on this optimistic promise that the kids will work it out.
Work it out. And I'm guessing they didn't. So he died at 66, and the problem started immediately.
Immediately. The first failure was structural, and it centered on liquidity. Because all his assets, the business shares, the property, everything was in his personal name. The entire estate went straight into the master's office administration process.
And what's the immediate painful consequence of that kind of legal freezing?
Within 4 months, Johann, the managing successor, found himself without clear ownership authority. He couldn't sign a major 8 million rand contract, a crucial piece of work. The other party required assurances that the business was legally sound, that he was authorized to sign. The client walked. That was the first major blow.
That's agonizing. Decades of reputation just undone by bureaucratic delay.
And that liquidity crisis only deepened when the estate duty bill arrived. It demanded 4.8 million rand within 12 months.
And there was no cash.
No cash. Because the commercial property was owned by the company and all the business assets were tied up in the frozen estate. To pay the tax, they would have had to sell company assets.
Which would instantly trigger
the compounding factor, capital gains tax.
This is where the structural flaw just destroys the family dynamic, isn't it?
It is. The family conflict began soon after. Francois, the uninvolved sibling, who now legally owned a third of a rapidly failing company, he immediately demanded his share, in cash.
But the others wanted to keep the business alive.
Exactly. Johann and Annelies wanted to save it, but they hit an instant deadlock. The lack of structure destroyed the operating relationship. Legal letters started flying between the siblings.
Wait, let's just sit with that for a moment. The collapse wasn't just financial, it was the total disintegration of a family. They went from siblings running a company to legal adversaries.
All because of an avoidable structure issue. That's the true cost of inaction. And the final fatal bomb arrived months later. Johann's divorce.
Oh, of course.
His wife's attorney immediately valued his stake at 16.5 million and claimed half under the accrual system. This introduced a hostile third-party claim over critical company decisions.
Complete chaos.
The result was inevitable. Desperate for cash, facing lawsuits, needing to settle the estate duties, they sold the business for a lowball 35 million.
A staggering 15 million rand loss.
And after all the duties, taxes, fees, and the divorce settlement, the sources describe the legacy as being gutted in 18 months. 40 years of work gone. And tragically, the siblings barely spoke afterward.
That entire tragic timeline provides the perfect motivation for Section 3. Let's pivot to the solution. This is where it gets really interesting. How did the Naidu family manage a successful transition? How did they prevent every single one of those failure points?
Well, Priya Naidu owned a successful manufacturing business, valued at 45 million initially. And her immediate divergence was recognizing that a will is for distribution, but a trust. A trust is for protection and control.
So she built her asset protection fortress well in advance.
She did, with specialized advisors. Her first move was a robust trust framework built on separation. The primary vehicle was a discretionary family trust, which acquired 100% of the operating company shares.
And that's the key move. It immediately removed the business shares from her personal estate.
Immediately. And she didn't just have one trust, did she?
No, she didn't. Critically, she used a separate special purpose trust to hold their high-value industrial property in Pinetown.
And that property was then leased back to the operating company.
Why that separation? For listeners thinking, why the extra paperwork? What's the point?
It's risk management 101. Look, the commercial property is a stable, appreciating asset. If the manufacturing company was ever sued for product liability or faced insolvency,
that multi-million rand property, insulated in the other trust, could not be touched by creditors.
Exactly. Protection from operational liability is paramount.
Okay, so let's look at the seamless succession. When Priya passed away 8 years later, what did the trust structure achieve instantly?
Complete continuity. First, no master's office interference, no probate delays. Her son, Vishal, was already a trustee and the identified MD. He stepped into the leadership role seamlessly.
So clients got immediate confirmation of stability.
Which avoided the contract loss that crippled the Van der Merwes.
And the tax liability.
The business assets, which had grown to 62 million rand, were legally owned by the trust, not Priya, so they were entirely removed from her personal estate.
No estate duty bill for those 62 million rand of assets.
None. Saving the family millions in immediate tax and preventing that whole liquidity crisis.
There was one protection story that really stood out from the sources about the creditor shield for the next generation.
Yes, the family safety net. When Priya Jr.'s husband's separate business failed, creditors naturally came looking at her family. But Because her interest was only as a beneficiary of a discretionary trust, not a direct shareholder?
The creditors had zero claim.
Zero claim over her potential future wealth from the Naidu business. The trustees had discretion. The family business remained completely insulated from a devastating personal financial crisis.
That is just the power of proactive, sophisticated structure. And today,
5 years later, the Naidu business is valued at $95 million. And Ravi, the sibling in London who isn't involved in operations, he still receives distributions funding his children's education. They're benefiting equally without any operational conflict.
so if we connect this to the bigger picture, this wasn't luck. It was the strategic implementation of what the sources call the 7 pillars of an asset protection fortress.
It was.
Let's get granular here. We need the full blueprint. Can we deconstruct these 7 essential structural elements for a listener?
Absolutely. Let's do it. Pillar 1, discretionary family trust ownership. This is the foundation. You remove all business assets and major investments from your personal estate. Maximum protection, continuity, and control.
Okay, pillar 1 is ownership. Then there's pillar 2, independent governance. This addresses the who. For any trust to be robust against SARs and the courts, you must include non-family members as independent trustees.
It's vital. This ensures impartial decision-making and proper governance, which is critical for the structure's legal integrity.
Makes sense.
Pillar 3, property and IP separation, just like the Naidus did. Keep your high-value, low-risk assets, property, intellectual property client lists separate from the risky trading company. Use formal lease or licensing agreements.
And pillar 4, Section 7C compliance. This is the urgent one for anyone who already has a trust.
This has to be fixed now. If you've loaned money to your trust interest-free, you must immediately remediate that. Formally document and charge the prescribed interest rate to avoid those massive deemed donation penalties from SARs.
Okay, that's a huge takeaway. What's pillar 5?
Pillar 5, robust succession documentation. This goes way beyond a basic will. It includes a detailed written succession plan, a clear letter of wishes to guide your trustees on your intent, and those essential buy and sell agreements.
And those are typically funded by key person insurance to provide instant liquidity, right?
That's right. Which leads to Pillar 6, liquidity planning. The Vandermeer failure was all about cash. A proper fortress ensures the estate has enough capital through life insurance held outside the estate or specific bank accounts to pay that sudden estate duty bill without selling core assets at a loss.
And finally,
Pillar 7, the annual review. Laws change, families change. If you don't conduct an annual fortress review, you risk non-compliance. What was perfect 8 years ago could be a legal liability today.
that list provides incredible clarity. But let's take a small step back. For listeners who are new to this, what exactly is a trust in the South African context?
So, a trust is a specialized legal arrangement. You transfer assets to a group of trustees, and they manage those assets with a fiduciary duty for the benefit of named beneficiaries, who are usually your family.
And for listeners who might not deal with the law daily, what exactly do we mean by fiduciary duty?
A fiduciary duty means the trustees must manage the assets solely in the best interest of the beneficiaries. I mean, they have to put the beneficiaries' interest above their own. They are legally and morally bound to act responsibly.
Which is why choosing that independent trustee is so crucial.
Feels so crucial.
You mentioned taxation earlier, and that's where people get nervous. Income retained in a trust is taxed at a flat 45%. That sounds really high. How does expert structuring mitigate that?
Well, that 45% rate is punitive, but only if the income is retained. Sophisticated structuring uses what's called the conduit principle. If the trustees resolve to distribute the income, say dividends, to the beneficiaries in the same tax year it was earned,
It flows through the trust.
it flows through, acting as a conduit, and is taxed at the beneficiary's personal marginal income tax rate, which is almost always lower than the trust's flat rate.
So the trust is the owner and protector.
Yeah.
But the beneficiaries are the ones paying the tax, usually at a much better rate. That really clarifies the value proposition.
Exactly, and that's why the choice between a discretionary trust and a vesting trust is a key strategic decision a specialist must guide you through.
Okay, now we come to Section 5, addressing the fatal procrastination trap.
Yeah.
Because I hear the same excuses all the time. It's too complicated, it's too expensive, and the worst one, my kids get along great.
Well, let's revisit the numbers to dismiss that expense excuse. The Vandermeer family lost 15 million rand. The average fees for establishing a custom, robust structure, they typically run between R150,000 and R400,000.
That is incredibly cheap insurance compared to paying R4.8 million in estate duty alone, let alone the losses from a total collapse.
It's a rounding error in comparison.
And what about the complexity excuse? It's not about how complicated it feels. It's about acknowledging that setting these up and maintaining compliance is complex, which raises the question, who do you turn to?
You must turn to specialized guidance. A trust consultant is not just an attorney who sometimes handles trusts. They focus specifically on designing and maintaining these structures. They don't just draft a document, they provide ongoing clarity and peace of mind.
The sources really emphasize that this professional guidance is critical. They help you build a custom structure, conduct those annual fortress reviews, and fundamentally, they simplify all the complicated jargon so you feel empowered, not overwhelmed.
And the practical recommendation for your next step is specific. Book a 30-minute consultation with a specialist. You just need an honest assessment to identify your personal and business risk areas and to see if a trust is even right for your unique circumstances.
For listeners who want to learn more about building this asset protection fortress, you can visit www.lumcasterman.com. That's LUMKASTUURMAN.com. Our team offers specialized services, from a foundation audit to identify risks, all the way to a full asset protection fortress setup.
The first move is always knowledge, that critical first assessment.
So what does this all mean? The difference between the Naidu legacy and the Vandermeer Way cautionary tale. It wasn't luck or love or even hard work.
No, both patriarchs loved their children and worked tirelessly. The difference was structure, planning, and proactive action.
It is the ultimate measure of successful planning. The Naidu family has Sunday lunch together. The Vandermeer children barely speak. The structure didn't just save the money, it saved the family.
It did. And the source material ends with this truly profound generational reflection. When asked about her success, Priya's great-granddaughter, who is managing the group 50 years later, reportedly said this: "My great-grandfather gave us more than a business. He gave us the structure to preserve it."
That is true generational wealth planning.
It is.
And that brings us to our final provocative thought for you to consider. If you had to answer the uncomfortable question right now, does your family business represent decades of sacrifice that deserves the same strategic thinking you used to build it? If you hesitated, even for a second, it's time to build your fortress.